Outlaw Law is brought to you by Whitaker and Hamer, attorneys and counselors at law. Your law firm for life.
Welcome back in for the final segment of the Outlaw Lawyers this week. Josh Whitaker and Joe Hamer, your hosts. They're the managing partners at Whitaker and Hamer Law Firm. I'm Morgan Patrick, consumer advocate. And I want to remind you that Josh and Joe are practicing attorneys here in North Carolina. Offices conveniently located Raleigh, Garner, Clayton, Goldsboro, Fuquay-Varina, and Gastonia. And if you have a legal question of your own, you can always call and get an answer. 800-659-1186. That's 800-659-1186. Leave your contact information, briefly what the call's about, and an attorney with Whitaker and Hamer will be in touch. And you can email the question to the show, questions@theoutlawlawyer.com. Gentlemen?
Well, you know, we didn't hit all of our teaser questions this week, Morgan, because we had so much to talk about. But one thing I did, I always like to end on a lighter note. But one of the things I did see, I saw an article that was just talking about how, Latin, how attorneys always use Latin. I remember before I wanted to be an attorney back in high school days, and people was like, oh, if you want to be an attorney, you need to take Latin, and that'll be super helpful to you. And I did. I fell for it. I took Latin for 2 years in high school. I don't know that it really helped me that much as an attorney, though. Joseph, did you ever take Latin as a foreign language?
Josh, I didn't. I did not take Latin, but it may not have helped you be a better attorney. But I think you're a fantastic attorney without having some Latin.
I appreciate it.
Regardless, but yeah, I mean, a lot of Latin terms pop up in the day-to-day of an attorney's life. So having some familiarity with that, it does not hurt. But again, there's but so much Latin that can be inserted into the legal world at the end of the day. 2 years of study, man. I'm proud of you for that. But yeah, I don't know that it's overly helpful.
Well, I don't know that it was, but I wanted to go over a couple of legal terms that we see or that come up a lot anyway. But I think I was starting thinking the one I see the most often. And I think the one I see most often is reference to something being ex parte, a motion, an argument, a filing, but something being ex parte. You know what that means, Joe? I'm going to quiz you. Do you know what that means?
I do, Josh. And, it can actually mean a couple of things depending on the way that it's being used. But in general, ex parte really refers to something that is of the benefit of one party in a legal case. So it's usually a decision that's made in favor of a party without really waiting for an opinion from the other side. It can also refer to improper contact with a party or a judge. So like if you have an attorney meeting, someone meeting with a party or a judge without a lawyer from the opposing side being present, that can be referred to as ex parte as well. So it has a few different meanings depending on the context.
Yeah, and then one we've seen. We've talked about this one a lot because I think when we first brought it up, we had to think about it because we don't deal with it every day. But remember when we talked about a writ of mandamus? Mandamus is
that was
term.
one of my favorite ones as well. So the word mandamus, literally meaning we command. It's basically an order from a higher court to really any public official or government agency or a lower court to complete a specific action. And it can't be used to make a court or that official do something that's against the law, but it can be used to order lower courts into making a decision or ruling when they've basically previously refused to give any kind of a ruling or judgment on it.
Yeah, we talked about that in connection with the Leandro case. There was a judge that was speculating that they could write a writ of a mandamus and order funding for schools, even though that's a legislative function. So we have talked about that one a time or two. One you hear a lot in everyday practice is de novo. And so de novo means,
is a common one for sure.
Yeah, so that just means you're in a situation where a court's going to look at everything all the way back to the beginning, right? So they're going to reevaluate the facts. You're basically putting on a new case. A court's going to hear something de novo, meaning from the new. So they're just going to start over. So that's one you hear a lot. And then pro se comes up a lot. And as pro se can be good or bad, but that's one when we see a time or two, Joe.
Yeah, that's one that you see a lot of non-attorney folks may be familiar with that term because pro se basically meaning on one's own behalf. It can also be translated to mean for oneself. and it refers to basically when you have a litigant or a person who has been charged with something who decides to represent themselves in court without the assistance of an attorney. So, any defendant or party in a legal case, they do have the right to refuse legal counsel and self-represent themselves, although we as attorneys don't necessarily advise that to be the way you go.
Yeah, and there's some statutes in North Carolina where you can't be pro se, right? So if you're in certain situations, if you're an entity, if you're a corporation, you're an LLC, and you're being sued or suing someone, there's certain times that you can't be pro se. You need to retain counsel, but small claims court, a lot of times you see a lot of pro se folks, plaintiffs and defendants representing themselves. It's kind of what to a large extent small claims is designed for. So you'll see there's evictions and the he said, she said, and breach of contracts under a certain amount. So that's usually where you see most of the pro se language. And then I think I had one more on this list, habeas corpus, which is one that you don't hear very often. But when do you use that one, Joe? Is that one doesn't come up in your day-to-day practice very often, I don't think.
It does not come up in my day-to-day practice very often. The literal translation is that you have the body. So I feel like that can describe me, but it usually refers to a writ of habeas corpus, which is something that's used by courts to determine whether or not the detention of a prisoner is valid. So when a court issues a writ of habeas corpus, that prisoner or detainee, in the case of someone who's admitted in like a mental health facility, will be brought before the court and their case is reviewed.
Good stuff, gentlemen. The Outlaw Lawyers, we have another one in the books. We got a Latin lesson right there at the end, but very interesting because we do hear those terms all the time. If you've got an issue that you are facing legally and you've got questions, call this number, 800-659-1186. That's 800-659-1186. Leave your contact info and briefly what that call's about. An attorney with Whitaker and Hamer will be in touch. And you can also email your questions to the show, questions@theoutlawlawyer.com. We're back next week with more of The Outlaw Lawyer.